Hello, my dear students. Welcome to HM Commerce Education. This is CA Mani Chandana. So, let's start with the Companies Act 2013. Okay, we have to start with Memorandum of Association, right? Till here, we have completed. I think incorporation of the companies is left. Apart from that, we have completed everything, right? One advice I would give you all is that before you start off with today's class, because there's been a long break, I could not record classes because of some health issues. I've told you already. So it's better, actually, it's my advice. It's better you revise whatever we have done till here, whatever we have completed. Kindly revise and then watch this particular video, or else you will lose the connect, right? Okay, very good. So let's start off with Memorandum of Association. You just have to pause the video right at this point of time, go back, just see, go through all the pages, make sure you know the keywords and you know that particular topic, and then it'll just take around max 20-25 minutes. Go sit there, go back to the initial pages, make sure you mark the keywords, or if you have already marked, if you have already revised, you know what are the keywords for each particular topic. So you just have to revise that particular topic and then come back to Memorandum of Association. That's it. Okay, not more than that. Okay, great, good. So okay, Memorandum of Association. See, children, we have been discussing about MOA, AOA, all these classes, right? Memorandum of Association, Articles of Association. So what exactly are these documents? Memorandum of Association, what exactly is this particular document? We are going to read it in detail. Okay, it's one of the key documents which we have to file while incorporating a company. During incorporation of the company, this is one of the key documents which we have to file. Right? So what is there in this particular MOA? Why is this so important? You will all learn it in this particular topic, right? Okay, come to page number 497, everyone, on our books, right? Page number 497. Good. Okay. The Memorandum of Association of the company is in fact its charter. Now, what's the meaning of charter? Students, charter is nothing but a legal document. It is a legal document which grants power to the company. Getting it? Right? It is a charter. A Memorandum of Association is its charter. What is a charter? It is a document, rather a legal document which grants the company its powers, right? Yes, ma'am. It defines its constitution and the scope of the powers of the company with which it has been established under this act. So whenever a company is being incorporated, it is given certain powers. In this Memorandum of Association, we have objects clause, which is very, very important, right? So this particular Memorandum of Association gives the company its powers through the objects clause, right? Ma'am, what is that objects clause? You will learn, right? So it basically defines the scope of the powers of the company. It also lays down the limits within which the company has to operate, right? Yes, it is a very foundation on which the whole edifice of the company is built. Ma'am, what is this edifice? What is this edifice? Some modern English, what is this? Nothing but, edifice is a structure, a very big, massive structure, right? So they're telling Memorandum of Association is so important. It is the very foundation on which the entire structure of the company is being built. I'm not talking about the structure. We are not it's not, you should not take the literal meaning of it. They are trying to tell the company is built, meaning it's not a structure or something else. It is the foundation. Memorandum of Association lays down the powers. It gives the powers to the company as to how it has to perform its business. So that is the base of the company. So that is how the company is being built, how it operates, everything. It is based on this legal document. That is what they're trying to tell here, right? Okay, clear. It's just the basics, right? Okay. Now, what is the object of registering a Memorandum of Association? What is the main object, or what is the purpose of this Memorandum of Association? Children, they're telling it contains the object for which the company is formed and therefore identifies the possible scope of its operation beyond which the company's actions cannot go. What are you trying to tell? It contains the object. Children, there are various clauses in this Memorandum of Association. You will learn all those clauses. Clause, C-L-A-U-S-E, clause, right? What are those clauses? You will learn. Name clause, registered office clause, capital clause. You also have this object clause, very important object clause. Now, what is the object of the company? Why is this company being incorporated? What is the purpose of this company? Say, for example, you take a real estate company. Take a real estate company. It has to write down in its objects what is the main purpose of incorporating this particular company. Say, for example, in order to buy and sell land or buy and sell properties, right? To let out the properties on lent or leasing activities, or to enter into joint venture. So I'm basically talking about real estate company, right? Say, for example, these are the objects of the company for which it is being formed. The company cannot do any activities beyond the given powers which are written in the objects of the company. So if a real estate company, if it has so and so objects, whatever I told, entering into contracts for building a particular building, or entering into contracts for selling or buying properties, or letting it out on lease or rent, or entering into joint ventures, all of these, right? So a real estate company has to, whichever company is being formed, should operate within these objects only, right? It has to operate into, now it cannot go and sell aircrafts, or a real estate company cannot go and sell mobile phones. It cannot go and sell some electronic items. Getting my point? Yes. So what are the objects for which the company is being formed is written in this particular object clause, right? So, and therefore identify the possible scope of operation. What is the scope of operations within which it can operate is being written in this particular clause, right? So that is the main purpose of the Memorandum of Association, beyond which its action cannot go. Obviously, the company cannot perform anything beyond the powers granted to it by the memorandum. Clear? Yes, ma'am. Okay, next, it enables the children, this Memorandum of Association is a public document. You will see here, it is a public document. What do you mean by public document? See, every person, you, me, everyone can have access to these documents, They are available. A Memorandum of Association of a company is what? Is a public document, meaning every person who wants to enter, it's not only who wants to enter or enter into a contract, whatever, that is the main thing, but all the public, you, me, everyone can have access to this Memorandum of Association. So you will read this. Let's see, a memorandum is a public document under Section 399 of the Companies Act. Consequently, every person entering into a contract with the company is presumed to have knowledge of the conditions contained therein. Children, we are going to do this in detail, don't worry. Okay, what they're trying to tell you, because this is a public document, whoever wants to enter into a contract with the company, he is presumed to have knowledge about what is written in that particular document. It is a presumption by law. That that person, whenever he is entering into contract with this particular company, has knowledge of whatever is written in the Memorandum of Association and also the conditions therein. Right, everyone? Yes. Next, it enables the shareholders, creditors, and all those who deal with the company to know what its powers and what activities it can engage in. So, if I am a creditor to the company, or if I am a shareholder of that particular company, when I invest in that particular company, I should know where my money is being used, right? Is whatever I'm investing in that particular company, where is my money being used? What are the risks? Here? The shareholders must know the purposes for which his money can be used by the company, and what are the risks he is undertaking while making that particular investment. Obviously, right? Yes or no? Yes, ma'am. Next, can the company depart from the provisions contained in the Memorandum of Association? Tell me. No, obviously. Then why is the entire thing being framed? Yes or no? Can the company depart from the provisions contained in memorandum? No, not in any case. It cannot depart from the Memorandum of Association. However imperative may be the necessity for the departure, how much ever it is necessary how much ever important it is for it to deviate from the memorandum, it cannot do so. It cannot. The company cannot deviate from the what? Memorandum of Association. How much ever important it is for the company to do so, it cannot. It cannot. Right? Yes. It cannot enter into a contract or engage in any trade or business which is beyond the power confessed on confessed on it by the memorandum. I told you, whatever is the powers of the particular company which is given in the memorandum of association, that only in that particular area it can trade or enter into business or enter into contracts or whatever it is. It cannot go beyond that. It cannot go beyond that. Ma'am, what if it does? Ma'am, what if it does? Yes, I have written in my memorandum that I am a real estate company. I can enter into so and so, so and so. Enter into JVs. I can build properties. I can build some. I can let out my properties for rent, etc., etc. What if I enter into a contract to sell mobile phones? What? No, I will do it. If that's the case, you want to do it, that is void. Whatever the contracts you enter into, that will be considered ultra vires the company. What do you mean by ultra vires? Ultra vires meaning beyond the powers, beyond the powers of the company. So when it is beyond the powers of the company, it is void. It is void. Void meaning what? It is no, it does not have any legal effect. Does not have any legal effect, right? Getting my point, everyone? So if the company engages itself in any trade or business which is beyond the powers confessed by it through the memorandum, it would be called ultra vires the company and void. And void. You will learn what is ultra vires to the company. We will do it in detail. Don't worry. Okay. So basically, ultra vires meaning beyond the powers. Okay. Fine. Good. Understood. What is Memorandum of Association? It is a charter of the company. Obviously, it lays down the powers of the company, it lays down the limitations of the company, it defines the scope of which the company has to operate, and it is the very foundation on which the whole building, whole edifice of the company is being built. What is the object or what is the purpose of Memorandum of Association? Ma'am, it contains the object for which the company is being formed, and it defines the scope of operations beyond which it cannot go. Very good. It also enables the shareholders, creditors, in order to, or the people who want, or the third parties who want to enter into the contract with the company to know where what are the powers of the company and where their money is being used. Yes, also the risks whatever the shareholder is taking while investing in that particular company. Getting it? Is a memorandum of association a public document? Yes, it is a public document. That is the reason whoever enter into contact with the contracts with the company is presumed to have the knowledge, of the memorandum of association. Right? Till here clear? Yes. Next, can a company depart from the memorandum of association? No. However imperative it is for the departure, it cannot deviate from the memorandum of association. Yes, if it does so, it is ultra vires the company and it is void. Right. Okay, till here, I think we are clear. Okay, next comes tables. Children, I'll do this little later. Okay, a little later. I'm not going to skip anything. We'll just come back to this once we finish the content of the memorandum. Once we finish the content of the memorandum, we will go back to the tables which are given in Schedule 1. Okay, don't worry. Right? Come to the content of the memorandum. Content of memorandum. Okay. Okay, I told you there are various clauses, right? See, children, if you are in, if you're, see, when I'm telling you, we are talking about memorandum of association. In practical terms, think. Children, you are not doing something in air, right? When we are talking about memorandum of association, you need to know what it is. See, ma'am is telling something, it is there something, it is not like school. It is not like how you study in school. Whatever is there, it is there. We don't have to worry much. Whatever is there in the book, we have to mug up. We have to just by heart and then go give it in the examination. No, everything is practical. If I'm talking about memorandum of association, this is something, a legal document which exists practically. Say, for example, if you want to check out the memorandum of association of Infosys, if you want to check out a memorandum of association of Tata, or keep it any company, you can do so. It is available. So when a company is being formed, when it has to get registered, when you say, for example, you have become a chartered accountant, a person comes to you, he wants to start a company. right? You have to, you itself, you have to sit down and do this memorandum of association for that particular person to incorporate a company for him. Getting it? So everything is practical. I'll show you. I'll show you the memorandum of Wipro. Do you know Wipro, a company, right? You have to learn it practically. There is no use just mugging up whatever is there in the books, because you are a professional, right? People will come to you for what? For advice, for your advice. You have to advise them. So you have to know what it is. You have to understand it practically. Learning law practically, not only law, keep it accounts, keep it audit, keep it law, be it income tax, be it GST, any subject you learn, you have to know it practically. It has practical impact, right? You will have to, you deal with income tax, you deal with GST on a daily basis, you deal with law on a daily basis, right? When you understand it is important for you in your life, the way you learn will become different. The way you learn changes. It is just not reading from the book. A doctor, for example, whatever he learns, he has to implement it, right? When you as a patient go to a doctor, whatever he has learned, he has to put it, he has to prescribe medicines, he has to do operations, everything, whatever he has learned should come out. The same way, in the same way, you as a chartered accountant, whatever you learn, you have to do it practically. So be very careful. Be very careful. Think that whatever you're learning now will help you in the future when you either practice or when you go to employment, right? Getting it? See, this is a practical, example. This is a memorandum of association of Wipro Limited. Do you know Wipro Limited? Yes. Yes or no? It's situated in Bangalore, right? It's a very famous company. You also can check out MOA of Infosys. You can also check out MOA of Reliance, of Tata, of Adani Group, of Airtel, of whatnot. You can download and check memorandum of association of all of these companies, of any companies for that matter, right? Okay, fine. I'll come back to that. Okay, I'll show you the memorandum of Wipro also in detail. Let's just see now. Okay, content of the memorandum. What did I tell you? It contains many clauses. The first one being name clause. Name clause meaning obviously the name of the company is being written in this particular clause. Next, registered office clause, meaning the state in which the registered office of that particular company is being registered will be given in this particular clause. Next, objects clause, right? Objects clause. Next comes liability clause. Next, capital clause, right? And then association clause or subscriber clause, right? So these are the various clauses which are mandatory for a company. These are the clauses which are to be mandatorily included in the memorandum of association of any company, right? We will do it one by one. Okay, what did I tell you? The first one being name clause. Now, what is a name clause? Obviously, the name of the company is to be written in this particular clause. Now, can you show us? Yes, children. See, this is clause number 1. Is it numbered? See, 1, 2, 3. Yes, is it numbered? Yes or no? See, these are the objects. Objects can be main objects and ancillary objects. Okay, these are all, see, so many objects here. Okay, fine. See, again, here comes 4. Yes, these are numbered. The memorandum of association is numbered and divided into paragraphs. See, so many paragraphs. Yes or no? Yes, yes, ma'am. Okay. So what did we learn? The first clause being the name of the company. The name of the company. What have they written here? The name of the company is Wipro Limited. Wipro Limited. What is this limited, ma'am? Come here. See? The last word limited in case of a public limited company. So whenever you see a company's name and next to it there is a word called limited. There's a word called limited, meaning it is a public limited company. Ayyo, we did not know all these days. Okay, right? So it is mandatorily according to law. You cannot write, I don't like adding the word limited. I will not add word limited. No, you cannot. It is mandatory. So if you are a public limited company, you have to have the word limited next. The last word of your company must end with the word limited, right? So if you are a private limited company, what should you have? You should have the last words as private limited. Say for example, ABC private limited. So if you see something, a company like this, obviously this is a private company. If you see something like XYZ Limited, what is this? It is a public limited company. Clear? Yes, ma'am. This clause is not applicable on companies formed under Section 8. You know, yes, Section 8 companies, they don't have to add the words limited or private limited towards the end of their names. You have learnt it, Section 8, we have done it in detail. You all know it. Yes? Yes or no? Yes, ma'am. Okay, fine. Next, the name including phrase electoral trust may be allowed for registration of companies to be formed under Section 8 of the Act in accordance with the Electoral Trust Scheme 2013 notified by CBDT. CBDT, Central Board of Direct Taxes. Ma'am, what is this? I've told you, it comes under Ministry of Finance Department in Indian regulatory framework. Yes, obviously, whatever in with respect to income taxes, this is the head, Central Board of Direct Taxes. Yes, CBDT, we call it as CBDT. Ma'am, one second, we did not understand what did you read right now in this particular paragraph. See, children, they are talking about electoral trust. Electoral trust. What are these? What are these? Children, these are Section 8 companies. These are Section 8 companies, meaning they are formed for not for profit. These are not for profit organizations. Yes or no? Meaning what? What is Section 8 company? Basically formed for not for charity purpose. Not for charity, allappa, not for profit. That is nothing but charity purpose. Yes or no? Or some other cause which you know. There are so many things which you have studied in detail. Section 8 companies. Yes. Have you revised? Did you revise today? I told you. If you have revised, you will get those points for scientific, for commerce, for that thing, for this thing, protection of environment, etc., etc., etc. For a cause. Yes or no? Yes. So these electoral trusts are Section 8 companies, basically not for profit organizations, and what these do is they collect donations or voluntary contributions from, say, could be anyone, from individuals, from companies, or partnership firms, or HUF, or AO, association of persons, etc., etc. So what do these do? They collect donations or voluntary contributions from individuals, companies, etc., and they what do? They distribute the funds to political parties, right? Okay, these are approved by whom? Approved by CBDT, Central Board of Direct Taxes, in accordance with electoral trust scheme 2013. Okay. Now, what are these? See, children, these electoral trusts are usually not for profit organizations. What do these do is they collect donations or voluntary contributions from individuals. Say, for example, I want to contribute to any political party. Let's not take names, but I want to donate or give contributions to XYZ party, right? I can do so by giving it to the electoral trust, right? These electoral trusts, what do? They further distribute these contributions to say XYZ a political party or ABC political party. Getting it? Everyone. Now, why do these do? See, these are regulated, children. These are regulated. These are approved by Central Board of Direct Taxes, and also they are formulated under some scheme, right? Getting it? So when the companies donate to such trusts, donate to such electoral trust, what do they get? They get benefit. So there are so many conditions put into this. Basically, for they get exemptions and deductions in income tax. when you donate through these electoral trusts, the companies or individuals, whoever are donating, they will get deductions from there. You'll understand that later. You will anyways have it in your income taxes. Don't need to worry much. Okay, basically, we just have to know what is this electoral trust. That's all. That was the main intention behind all of this. Okay, but why do we have to know what is an electoral trust is because when an electoral trust is formed, it can have the name electoral trust besides its name. Say for example, ABC Electoral Trust, ABC Electoral Trust. Getting it? Getting it? Why did we learn all of this? Just to know that, see, the name including phrase electoral trust may be allowed for registration of companies to be formed under Section 8 of the Act in accordance with so and so. So you can have a electoral trust with the name ABC Electoral Trust or XYZ Electoral Trust. Getting it? We are talking about name clause. So in this name clause, we are learning so many things. First, what did we learn? Public limited company ending limited, private limited company ending private limited, right? Section 8 companies, it is not applicable. Yes, limited or private limited is not applicable. But in case of electoral trust, the company can have in next to its name the phrase electoral trust. Getting it? Also, for the companies under Section 8, then what shall it include in its name? Say for example, foundation, forum, association, Tata Foundation. Yes, Tata Foundation, say association, some Bangalore Cricket Association, right? Federation of Industry of Chambers and Commerce, right? Commerce and Industries, then Chambers, Confederation, Council, Electoral Trust, and the like, etc. So what they're trying to tell, for Section 8 companies, all of these are allowed. It shall include. So if you're incorporating a Section 8 company, then the name shall include either foundation, forum, association, federation, chambers, confederation, next council, electoral trust, etc. Right? Getting it? Yes, ma'am. Next, as per MCA notification dated 5th June 2015, okay, government company's name must end with the word limited. With the word limited. Say, for example, if you are a government company, what is a government company? Have you read? Have you revised? Yes or no? Yes. Okay. No, go back. Okay. So it has to have must. Must is shall or must meaning mandatory. In law, these are all law words. Okay, if it is must, you have to write in your exam also, you have to make sure you have to use must only. Must or shall. You cannot write may. You cannot write may. Getting it? May or can, you cannot use. If it is must, meaning it is mandatory. Right? Must end with the word limited. Government company, word limited. Getting it? I don't use short forms in your exam. Limited meaning limited. Okay, yeah. In case of one-person company, what is one-person company? You all know. Yes. Did you revise? Yes. No. Yes means you can continue. If you have not revised, go back. Okay. So one-person company. So the words one-person company. The words one-person company in inverted commas. So say for example, below its name ABC, you have to write one-person company. So people have to understand, that you are a one-person company. People have to understand that you are a one-person company. What if they think you are a public limited company or if you are a private limited company? Getting it? Yes or no? Yes, ma'am. Fine. This is about the name clause. This is about the name clause. The first clause of the memorandum is done. Okay. Did I show you? Yes, I think. Yeah. See, the name of the company is Wipro Limited. What do you mean by Wipro Limited? This is a public limited company. Correct. Yes. Next comes which clause? Next comes the registered office clause. Next comes the registered office clause. Okay. The state in which the registered office of the company is to be situated where will the is to be situated, meaning what? The company is not yet incorporated, right? So in that particular memorandum of association, you are going to write the state in which you will set up the registered office of the company. You will set up the registered office of the company. Which state? Wipro is from Bangalore, meaning Karnataka, right? See, the registered of the company will be situated in the state of Karnataka. Will be situated in the state of Karnataka. Getting it? Right? If it is in Maharashtra, it will be in Maharashtra. If it is in some other state, Uttar Pradesh, it will be in Uttar Pradesh. It is from Kerala, so somewhere, say some part of Kerala, then it is state of Kerala. Getting it? Everyone? Yes. Okay, next. The objects for which this is done. The second clause is also done, which is that the registered office clause. Next, the objects for which the company is proposed to be incorporated and any matter considered necessary in furtherance thereof. That is the objects clause. So the main purpose for which, it is very important. This particular clause is very, very, very important. So we as chartered accountants in practical life, when we incorporate a company, we will pay a lot of attention to these objects clause. You all know we are practicing chartered accountants. I am a practicing chartered accountant. So when we, incorporate a company, a lot of detail, we try to make it as detailed as possible, this particular clause, because we do not want the company to face any problem later on. Getting it? So we'll try to include as many, objects as possible for that, to increase the scope of that particular company, to increase the scope of its operation. Getting it? So I'll just show you the objects of this particular company, Wipro. See, the objects for which the company is established are following. See, to purchase or otherwise acquire and take over any lands, okay, with or without building and plant, machinery, factory, etc., etc. To carry on business of extracting oil either by crushing or by chemical or any other process, etc., etc. For see, castor oil, groundnuts, any other nut or seeds whatsoever. To manufacture and deal in hydrogenated oil, vegetable oils, vegetable ghee substitutes, vegetable water, etc., 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 etc. Right? See, whatever the kinds of objects the company wants to do business in, what are the purpose for this particular Wipro is being formed, right? To carry on business of manufacturers, sellers, etc., exporters, importers, etc., etc. To carry on mechanical engineers, tool makers, brass, metal founders, all of these. You just go on and goes on and on. See, manufacturer, assembly, to carry on research and development. You also have ancillary objects. You also have ancillary objects. Now, what are ancillary objects? The objects which are ancillary, meaning secondary to those main objects, which help to achieve the main objects. Okay, that also in, I don't think in this it is given. You can check out in any other memorandum of any other company. You also have ancillary objects. Okay, so which help in achieving the main objects of the company. If you can see here, see the objects of this particular company, it goes on and on. To carry on business of tin makers, what not, generate, accumulate, supply electricity, to acquire, establish, provide. Oh God. See, it still did not end. All of these are objects only, objects clause. Okay, fine. Till here, no. See, these are amended objects, children. See, these are amended objects. The amended wide resolution passed by members at annual general meeting. See, if the company wants to enter into any other business, a different line of business, obviously the memorandum, if it is not that particular business is not there in the memorandum, you have to alter the memorandum. You have to alter the memorandum. So these are the altered business objects, right? This one, and there's one more. See, even this is amended. This particular object is also recently introduced. In 2008, it has been introduced. Okay. So yeah, till here. It is objects of the company. See, practically, Wipro is doing so many businesses. So is it really allowed to do such business? Yes, it is allowed. How will you get to know? Come to its memorandum of association. If Wipro is doing so and so business, you can check whether it is allowed to do so. How do you check? You go to its memorandum of association, check the objects clause. If it is there, yes, it is good. If it is not there, it is ultra vires. So you cannot enter into that particular business with Wipro. Getting it? Yes. Yes, ma'am. Okay. Come. Objects. Fine. Good. If any company has changed its activities which are not reflected in its name, it shall change its name in line with its activities within a period of 6 months from the change of activities after complying with all the provisions as applicable to the change of name. So what I'm trying to tell you here is, say for example, we have started a business. Say for example, HM Airlines. HM Airlines Limited. Okay, HM Airlines Limited. Now, what happened? Because of so much of losses in this particular business, we had to stop that particular area of business. HM Airlines full loss. Ella kade loss. You put domestic airlines also loss. Put international airlines also full loss. So what we decided, okay, this is not happening. It's not in our hand. We'll do one thing. I will shift to say some other business. Say for example, we'll shift to which one? Hospitality sector. Okay. HM, okay, hospitality sector. So, what is hospitality? So, for example, we have entered into hotel services. Okay, hotel services. Now, my name is HM Airlines Limited. And what am I doing? I'm running airplanes. No. What am I doing? I'm providing hotels. Hotels. Say what hotels? 3-star hotels, 5-star hotels. Under the brand name of under the name of HM Airlines Limited. Think. What should I do? I should change my name, no? Yes or no? Yes. So HM Airlines Limited, I should keep it as HM Hospitality or Hospitality or HM Hotels, whatever, or HM Hotels Limited or whatever. Yes or no? What is the period given for me to change? Period of 6 months. What is the time limit given to me? It is a period of 6 months from the change of activities after complying with all the provisions which are applicable for the change of name. So whatever are the provisions which are applicable to change of name, you follow all of that, and you have to change your name within 6 months from the change of the activities. Getting it, everyone? Yes, ma'am. Okay. Next, object clause is done. Yes, object clause is also done. Next, come to liability clause. Come to liability clause. Okay. Yes. Okay. The liability of the members of the company, whether limited or limited, it has to state in the memorandum of association. You have to state whether your company is limited by shares or limited by guarantee. You have to state. See here, the members of the liability of the members is limited. This is what they have stated. They have not written anything else more in this particular company. But basically, you have to include. You have to include. See, you have to state. That's correct. That's not wrong. Okay. The liability of the members of the company, whether it is limited or unlimited, it has to state. If it is company limited by shares, it has to also state that the liability of its members is limited to the amount unpaid, if any, on the shares held by them. This should be written in the MOA. The memorandum of association should have this particular line in being stated. It is not there here, but it's okay. But it should be there. I don't know why they're not included, but you can check any other memorandum. It will be there. They'll also state the liability of members is limited. See, like this, liability of members is limited. Along with this, there will be one more line here, which will state that the liability of its members is limited to the amount unpaid, if any, on the shares held by them. Getting it? This is for a company limited by shares. Okay, if it is company limited by guarantee, then the amount up to which each member undertakes to contribute to the assets of the company, they have to state this particular line. I'll show you. See, for your confirmation, I'll just show you. So, see, this is the schedule 1. I told you the table ABC, right? So, in this, you will get. See, this is the clause. The liability clause. See, this is the format, children. This is the format in which the MOA has to be formed, to be framed, right? When we in our practical whenever we incorporate a company, we will see whether a company is limited by shares or whether a company is limited by guarantee or by both. So we will take which particular table is applicable to that particular company. You will just, in some time, I will teach you that also, right? We will have to see there is table A, there is table B, there is table C. So these are various formats. This is nothing but the formats given for that particular company. Say if you are a company limited by shares, you have to follow table A format of memorandum of association. You are, say for example, you are a company limited by guarantee and not having share capital, then you have to follow this particular format, table B format. If you are some other company, which is that company limited by guarantee and having share capital, you have to choose MOA, which is given in the format table C. Getting it? Yes, I'll show you. Come. See here, the memorandum of the liability of the member is limited. Yes, they have stated. They've also stated, see, this is a company limited by guarantee and not having share capital. Okay. Wait. Limited by shares. Company limited by shares. Here, the company liability of the members is limited. Yes or no? And they also have to state that this liability is limited to the amount unpaid, if any, on the shares held by them. This is there. Now clear. This is the format, children. This is the bare act. Whatever I'm showing you, it's the bare act. If you remember, we have, I'll show you, wait. This is the bare act, children, wait. Page number 1, if you go, This we have, I have already showed you in our first class. This is the Bare Act. These are the schedules. See, these are the chapters, chapter 1. All this is the act. These are the definitions. We have discussed all of this. So in this only, you will also find the schedules. You will also find the schedules. In that, first schedule is about the memorandum, of association, right? If you are wondering, ma, what ma'am is doing, where is she showing all of this? Practically, I am trying to show you. If you understand, it's very good. Okay, because when you become a chartered accountant, you all have to know all of this. Well, it's very difficult. No? So Schedule 1 of the Companies Act 2013 gives the formats for Memorandum of Association. Okay, now come to a company called come to a different company limited by guarantee and not having share capital. So this particular thing should not be there. Company limited to the amount unpaid, if any on the shares held, that will not be there in this for this particular company. What else will be there? See, every member of the company undertakes to contribute to the assets of the company in the event of its winding up, so on so and to the cost, charges, etc., etc. This is included. This is what is there in your book. Check it out. Yes or no? See. Yes, this is what is there in your book. Correct. Right. Now let's understand what is this, ma'am. Ma'am, what is this? What have they tried to write here? See, if the company is limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member or within 1 year after he ceases to be a member for the payment of the debts and liabilities of the company or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and to the cost. Okay, ma'am, I know you have not understood anything. Just you can whatever, wherever you have space here, you can just write down. Okay, let me simplify it. Okay, say for a guarantee company, at the time of winding up, yes or no, at the time of winding up, only the member will have to contribute. Yes, ma'am. So the member has to contribute if he is a present member, if he is still a member of that particular company, then he has to contribute to the to all of the liabilities and debts of the company up to the guaranteed amount. So if for example, if he has guaranteed 10 lakh rupees, so if he is still a member of that particular company, so the shortfall has to be made good by this particular member. He is still the member of the company, and up to 10 lakhs he has to give it to the company. Okay, now this person, he is not a member. Say for example, up to one year after he ceases to 1 year. What is this? Okay, within 1 year after he ceases to be a member. 1 year after he ceases to be a member. Then for what is he liable to? He is liable for the liabilities and debts which were contracted while he was a member. Okay, this is the meaning of that. The wordings are not that clear, but basically what happens is, in case of a guarantee company, if you are a member, then you have to, at the time of winding up of the company, you will have to pay the amount you have guaranteed. Yes. So if you are still a member of that particular company, then you will be liable for all the liabilities and debts of the company. But what has happened? You have ceased to be a member. You are not a member of that particular company. Then what is your liability? Then for 1 year after you cease to be a member, you will still be liable for the debts and liabilities made by the company when you were a member. So when you were a member, the company has entered into some contract and it has entered into some debt. It has took some debt. So you will be liable even though you are not a member of that particular company for a period of 1 year. For a period of how much? For a period of 1 year. Clear? Okay. So don't worry, this is what has to be stated in the memorandum of association of the company. I also showed you that particular, not here, yeah, that particular line, correct? That particular clause. Yes or no? Yes, see, this particular clause. If you are a guarantee company, right? Okay, and also to the costs, charges and expenses of winding up. That also you have to contribute. You as a member of the guarantee company, you will have to contribute to the cost of winding up. Okay, right? Fine. So we are done with the liability clause. We are done with the liability clause. Good to go. Next, the amount of authorized capital, the capital clause. Next comes the capital clause. Ma'am, what should we state in this particular capital clause? See, the authorized capital. What is authorized capital? The maximum amount of capital. You have revised, you have learned. Yes, yes. Then stay here. If you have not revised, go back, revise, and then come back. Okay, good. I hope there's nothing wrong with the video. Yeah, okay, fine. Okay. Fine. Authorized capital divided into share of fixed amounts and the number of shares with with the subscribers to the memorandum have agreed to take. Okay, ma'am, we want to see it practically. Very good. Come, children, we will see it practically. See, the authorized share capital of the company. See, how much is it? How much? Rupees 25 crore, 27 lakh. Yes or no? 25 crore, 27. No, 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 it's not 25 crore. It is 2,527 crores. Oh my God. Yeah, just 2,527 crores and 40 lakhs. Fine. The Wipro authorized share capital. Okay. Good. Good. Fine. This is the authorized share capital of this particular company, Wipro. God. Okay. Fine. So it has to state the number of divided into share of fixed amounts and the number of shares. With the subscribers. This is nothing but the subscriber clause, children. Association clause, also called as subscriber clause. Subscribers clause. This should state the number of shares which are taken up by the subscribers to the memorandum. What are the number of shares which are taken up by the subscribers to the memorandum who initially start the company? How much number of shares they are taking in? Okay, you can see the same thing here also. See, this is the detail of the subscribers to the memorandum who are initially while incorporating a company. The subscribers to the memorandum are the ones who have started that particular company. Okay, see, the memorandum shall include with the association clause. Okay, every subscriber to the memorandum shall take at least one share and shall write against his name the number of shares taken by him. I'll show you. Come here. Okay, see, these are the subscribers to the memorandum. All of these persons, these are the subscribers to the memorandum. See, they have given their address and the number of shares which they have taken. These are the number, at least one, minimum one. What they have told, at least one share. These people, see, this particular person has taken 50 shares, this particular 100, 50, 50, 50, 100, 100. Yes, also witness. Also, the witness have also signed. This is nothing but signed. It's a copy. This is not the original copy. Usually, when we actually do a memorandum, here they'll sign. Here they will sign. Okay, all of these people, even these people will sign. Witnesses also will sign. The subscribers to the memorandum also will sign in this particular memorandum of association. Getting it right? Yes. Yes, ma'am. Okay. So are we clear with the clauses? Are we clear with all the clauses? Yes. And also, children, in case of OPC, there will be one more clause of, see, I'll show you. We will go to the format. I'll show you. In case of OPC, the name and address of the person who wants to start the company. That is the OPC. This is for OPC, the member of OPC, his details, and also the details of the nominee. Also, the details of the nominee should be included in the memorandum of association of that particular OPC. You can see in any of these formats, you will find if it is OPC, these should be included. See, in case of OPC, the person whose name is to be included, who's forming the company, that person's details and also the nominee details. Also, the nominee details will be given in the memorandum of association. Right, everyone? Yes. Okay, see, I'll just show you. In the case of OPC, the name of the person who, in the event of the death of the subscriber, shall become the member of the company shall be stated in the Memorandum of Association of the company. Okay, fine. They're talking about the nominee. Very good. Okay, then fine. We are done with all the clauses. We are done with name clause. We are done with registered office clause. We are done with. Okay, ma'am, how to remember all of these? Ma'am, please give us a memory technique so that we can remember all of these clauses. Okay. Just write it down. Uh, where will you write down? If you have space somewhere, just write down. Okay. Enroll for CA. Enroll for CA. Have you enrolled for your CA foundation? Yes. If you haven't, you cannot give your exam. Fine. Okay. Enroll for CA. What is this, ma'am? N for children, name clause. N for name clause. R for registered office clause. R for registered office clause. O for objects clause. Yes. L, ma'am, what does L stand for? L for liability clause. L for liability clause. Next, C. C for capital clause. C for capital clause and A for association clause. A for association clause. Getting it? So, Memorandum of Association, what are the various clauses? Enroll for CA. Enroll for CA. E is silent. Don't have to worry. I mean, don't have to crack your head. Ma'am, what is this E? For you also, we will make one more clause. No. Enroll for CA. Starting from N. N for name clause. R for registered office clause. Then O for objects clause. L for liability clause. C for capital clause. And A for association clause, which is also called as subscribers clause. Subscribers to the memorandum. Okay. Clear? Name clause, we are clear. Okay. Next, objects clause, registered office clause, objects clause, then authorized capital and association clause. Yes, everyone clear? Okay. Then the memorandum must be printed. It must be divided into paragraphs. It must be numbered consequently and signed by at least 7 persons. Okay. If it is a normal company, if it is private company, then 2. If it is 1-person company, then 1. Okay, if it is 7 person, who are these 7 persons? 7 persons who are the subscribers to the memorandum, public company. In case of private company, it is 2. 1-person company, it is 1. Yes, in the presence of at least 1 witness who will attest the signatures. Witnesses should also sign the memorandum of association. Yes, yes, ma'am. Okay, they'll also write the particulars about the signatories to the memorandum as well as the witness as to their address, description, occupation, etc. must also be entered. You all saw, right? See here, there are 7, I guess. See, 1, 2, 3, 1, 2, 3, 4, 5, 6, 7. Yes, 7 people, 7, 8. Okay, minimum 7. Okay. 7 and also the witnesses. These are the witnesses. And see, all of these, the address as to the subscribers is also been given. Right? Yes, ma'am. Okay. Fine. Next, it is to be, okay, printed, divided into paragraphs, numbered consequently. I have already shown you. Yes or no? Yes, ma'am. It is to be noted that the company, being a legal person, can, through its agent, subscribe to the memorandum. Okay, tell me if whether a company can become a member of another company. Can a company hold shares of a different company? Yes or no? Can a company hold shares of another company? Yes, right? Yes or no? Yes. Hey, come on. What have you studied about holding subsidiary, associate company and all? If you don't know this, then what have you learnt in holding associate, subsidiary company and all? Obviously, yes. A company can hold shares of another company. Yes. Basics, please. Okay. So, in case of that, it can act through its agent. Will subscribe to the memorandum of that particular company. Okay. However, minor cannot be a signatory to the memorandum as he is not competent to contract, because he has not attained the age of majority. He is still a minor. He is not competent to contract, so he cannot become a signatory to the memorandum. Then who, ma'am? The guardian can do so in his personal capacity. Okay. Yes. Next. Okay. These clauses of the memorandum are called compulsory clauses or the conditions. Ma'am, I told you all of these clauses are compulsory. They are compulsory in a memorandum of association. Can we add extra? Yes, you can do so. Okay, in addition to these memorandum, they may contain other provisions. For example, they've given some example, rights attached to various classes of shares. Say class A shares, class B shares. Class A shares will have so and so, they'll have so many voting rights. The class B shares will have so and so voting rights. You can change, you can add on to this, but these must not be skipped. All of these clauses should be there in a memorandum of association. If you want to add something else, you can do so. Okay. Next, the memorandum of association of a company, usually it is the same. And if you have to add, if you say, for example, whatever you have seen here, and in practical purpose, there are other things also which we will include in memorandum of association, which you can do. Okay. Next, the memorandum of association of a company cannot contain anything contrary to the provisions of the Companies Act. You cannot write in your memorandum of association something which is contrary to the Companies Act. Act will prevail. Your memorandum of association, set aside. Set aside. You cannot change the act. Whatever is there in the act, that will prevail. Your memorandum cannot override the law. Your memorandum of association cannot override the law. Getting it? Yes. If it does, the same shall be devoid of any legal effect. It does not have any legal effect. Similarly, all other documents of the company must comply with the provisions of the memorandum. Okay. Fine. Are we clear? Yes. Yes, ma'am. Okay, come back to the tables, children. I think by now you should know those tables also, but just I'll show you again. See, as per section 4, memorandum of a company shall be drawn up in such form as is given in tables A, B, C, D, E in Schedule 1 of the Companies Act 2013. Ma'am, what is this? See, I have already shown you certain tables. Okay, basically these tables are given in Schedule 1 of the Companies Act. If you see the Open the Pair Act, you will see the chapters, you will see the section numbers, you will also see the schedules. In these schedules, you will have various tables. So table A is for whom? This is a format. It is a format given to what kind of companies? Company limited by shares. So if you are a company limited by shares, you have to follow the format of memorandum of association given in table A. Yes, yes, ma'am. So if you are a company limited by guarantee and not having share capital, you have to have a memorandum of association given in table B, of Schedule 1 of the Companies Act. Next, if you are a company limited by guarantee and having share capital, then table C. Then if you are a unlimited company, then table D. If you are an unlimited company having share capital, then table E. Ma'am, practical. You want to see? Yes. Okay, see. Table A. Table A is for what? Company limited by shares. Table B is for company limited by guarantee and not having share capital. Table C. Memorandum of Association company limited by guarantee and having share capital. Yes or no? Then table D is for unlimited company not having share capital. Unlimited company not having share capital. Next, unlimited company having share capital. Unlimited company having share capital. You can see the liability of the members is unlimited. Yes, but also you also have one more clause wherein the share capital of the company is divided into so and so rupees divided into shares of so and so rupees each. If you go to the previous one, not having share capital, you will not have this particular clause. You will not have this particular clause. We'll go and check. Come. See, you only have liability of the members is limited. Because this is not having share capital, that particular clause which is relating to share capital is not there in this particular format. Are we clear? Practically, did you understand? Yes, everyone. Did you understand? Yes, everyone. Good. Yes. Okay. Let's stop here. Fine. Next, we will do doctrine of ultra wires in the next class. Okay. Fine. Right, children. Thank you.